make plainly certain to assert. Basically, you can also refer to it as a proof. In Malaysia, with reference from my previous slides, I have mentioned about the sources of law. Evidence Act 1950 Section 3 defines evidence to include all statement which the court permits or requires to be made before it by fact under inquiry. Such statements are called oral evidence. The oral evidence is basically about the speech, speaking of the fact, speaking of what happens, speaking about the material fact in front of the court is what the oral evidence is about. The oral evidence is produced by the witness. The competency of the witness will be assessed by the court before allowing them to so the witness have to take the oath, sumpah. B. All documents produced for the inspections of the court. Such documents are called as a documentary evidence. So the documentary evidence is quite interesting because in the documentary evidence there is a primary evidence and secondary evidence. Category is categorized in that way because the primary is the original document, the secondary is a duplicate copy. To put into simple way, the secondary normally comes as a photocopy of the primary evidence report. So Section 3 of the Evidence Act 1950 uses the word includes. Thus, it is not exhaustive. It may also include real evidence. For example, any substance, things tendered as an exhibit such as clothes, drugs, murder weapons, or the strand of hair. So the real evidence is considered as a direct evidence which can be seen, which can be felt. So here we can say that if you found the clothes, the physical items, it will be regarded as an exhibit and it is included within the Section 3 of the Evidence Act 1950. It can be something which tends to prove the existence or the non-existence of some fact which it may consist of documentary evidence and the real evidence. The law of evidence. So as defined above, must not be confused with the law of evidence which has much wider meaning and scope. The law of evidence comprises all the rules governing the presentations of information concerning fact in disputes and the proof in the proceedings before court, including in particular the rules governing the relevancy and admissibility of the evidence. Itself is the relevancy and the admissibility. This item submitted to the court is logically relevant to the case, and then the admissibility of the evidence. How the court accept such evidence? What is the rules? What is the reasons, rationale for the court to accept such evidence in the trial proceedings? The law of evidence is based on the maxim lex fori, which means the governed by the law the place where the dispute arises. So here, if let's say we have Australian case here, Bain versus White Level and Furnace Punches Rabel, the Lord Birmingham observed that the law of evidence is the lex fori. Whether a witness is competent or not, whether a certain matter required to be proved by writing or not, whether certain evidence proves a certain facts or not, that to be determined by the law of the country where the question arises, where the remedy is sought to be enforced, and where the court seeks to enforce it. So this case is basically talks about the jurisdictions of the matter. Hence that where did this crime happen, where these transactions happen, where the evidence obtained. In that country jurisdiction is how the law is going to